This is AZ Court Help Legal Talk on How to Write a Will by Carrie Rednour of Rednour Law Offices. Thank you.
How to write a will. So the first thing I'll say is, generally speaking, it's a good idea to hire an attorney to write the will for you. We're going to talk about all that sort of stuff, but my general advice would be, if you can do it, hire an attorney to do it. It's always better, in my opinion, to have an attorney write a will for you. And there's lots of reasons for that. The first being that the most contested wills are wills that are written by a person and not done by an attorney. When somebody tries to write a will themselves, a lot of times, they make a mistake, and then that leads to some litigation, people contesting it, all that sort of stuff. If you have an attorney write it, it's more likely that it's going to be done correctly. Not always, of course, but it's more likely that it's going to be done correctly, but also that there's other reasons that a will can be objected to, which I'll talk about. And if you use an attorney, it's less likely that you're going to have a problem with those kinds of issues because an attorney has prepared it. So I'm going to start with just the basics of the execution requirements of a will. So in Arizona, in order to have a will be valid, it has to be in writing. It has to be witnessed by two people. Those are the only requirements for a will, for the execution of a will to be valid. So it must be in writing and it must be witnessed by two people. There's also, so that's for a formal will. There's also a way that you can write a handwritten will that doesn't have any of those requirements. So the first thing is a will in writing and witnessed by two people. That's the basics, right? Is in writing and witnessed by two people. That can be typed. The will in that circumstance can be typed and on, printed out, whatever. There's also what's called a holographic will. And so a holographic will is a will that's in your own handwriting. Must be in your handwriting, and then it doesn't have to be witnessed by anybody. So if you do a holographic will, again, it must be in your handwriting and it must be signed by you. I don't recommend that people do that because, again, when you do that, that's much more likely that a mistake is going to be made and something's going to go wrong and you're going to have a problem. But the law does allow it. So again, it must be in your handwriting. So that's not somebody else writes it for you and you sign it. That's not, you get one of these forms that has some of it typed and then you handwrite the rest. Generally, that doesn't work, not for a holographic will. So again, holographic means in your handwriting and signed by you. And if you do that correctly, so you can literally handwrite it in your handwriting and sign it. And if what is contained in it covers everything, that can be a perfectly valid will. And it does not have to be witnessed. It does not have to be notarized. It's perfectly valid if it's in your handwriting and signed by you. And that's what's called a holographic will. Now, again, I'll go over sort of what needs to be in the wills in a minute. So that's a way to do it. The other way to do it is if you have a form that has typing on it and you want to fill that in, you can do that, but then that's going to need to be witnessed. And so that requires two witnesses. There's another provision in the law that provides that you can also have it notarized. So that's sort of the best way to do it, is have two witnesses and a notary. What the notary provides to you is what's called self-proving. So what happens is in a normal will that's typed and witnessed by two people, if there's any kind of question later about the execution of the will, you have to track, or somebody has to track down those two witnesses. And those two witnesses are going to have to either testify or provide an affidavit that they witnessed this document, they witnessed you signing your will. If instead you get it witnessed by two people and notarized, then that's sort of, it's this conclusive presumption that it was executed properly. So you don't have to, or your family doesn't have to chase down these witnesses and try to locate them. So generally speaking, pretty much all the attorneys, at least the attorneys that practice in this area of the law, have it witnessed and notarized, because that just makes it a much easier process if it has to be probated later. And I'll talk about probating a will and what that means also when we get to that point. So those are the execution requirements. So that's sort of the, how do you actually, take care of signing this document? So then the next issue is, what should be in the will? There's some basics that you need to have in the will to make it effective. So a lot of people, this is a mistake a lot of people make. Okay, well, I'm going to give my Bank of America account to my son, Joe. I'm going to give my car to my friend, John. And I'm going to give my house to so-and-so. Well, and then that's it. That's all they say. Well, they might have a lot more assets than that. Maybe at the time they wrote the will, they didn't have anything else, or maybe they did. But in any event, now that's not complete because it doesn't have what we call a residuary clause. A residuary clause says, I leave everything to so-and-so. If you don't have that, you're going to have a problem, because it's very unlikely that you're going to be able to list all of your assets and not leave something out. So you must have a residuary clause that says everything else goes to whoever you want it to go to. If you don't have that in the document, then you have a problem, right? So then what happens? Well, what happens is that it goes to your heirs. And so the heirs are determined under the statutes, the Arizona statutes. So that obviously, right, you've prepared a will and now it's not really valid because you've left a big, big hole there. So that's what you need to make sure you understand. If there's certain things that you want to go to certain people, you can definitely do that. You can say, I want this asset to go to this person. I want this asset to go to this person. But then you must have, here's where everything else goes. I want everything else to go to so-and-so. Like I said, a lot of people want to say, well, I want this asset to go to this person, this asset to go to this person, this asset to go to this person. It's fine to do it that way. The problem that you have to keep in mind is, well, let's say that, I want my Bank of America account to go to my son. I want my Wells Fargo account to go to my daughter. What's really your intent there? Is that they each get, a certain amount? Right now, maybe the amounts in your Wells Fargo account and your Bank of America account are equal. Are they going to be equal when you die? Maybe, maybe not. So you have to keep in mind that once you start doing that, the results could be vastly different from what you intended. So, maybe right now your Bank of America account has $50,000 in it and your Wells Fargo account also has $50,000 in it. But as time goes on, maybe you're using that Wells Fargo account for your expenses. And so maybe when you die, there's, $1,000 in there. So now your daughter gets $1,000 and your son gets 50,000. So you really have to keep that in mind about what your intent is and how you want to work that out. My general feeling, the way that I believe that it works out best, is just to have, I give everything to my son and daughter equally. That's it. And not delineate these assets out, because things can change. Plus, what if you close one of those accounts? What if you decide, well, Bank of America, I don't like Bank of America anymore. It's not convenient or whatever. I'm going to close that Bank of America account. Well, now you don't have that account anymore. So it's not going to your son, but your daughter's still getting the Wells Fargo account. So you really just have to, those are all things that a lawyer can talk to you about and work it out. But again, if you're going to do it on your own, just be aware of that sort of thing. Again, my suggestion would be that you just say everything goes however you're going to go. Some people also want to say, well, I want to give, dollar amounts to people, $5,000 to this friend, $10,000 to this person, maybe to some charities, maybe something like that. Again, that's perfectly fine, as long as you keep in mind that those have to be paid first. If you start putting high dollar amounts on those are called bequests. If you start putting high dollar amounts on those bequests, you might not have enough money to cover those, first of all. But even if you cover them, there might not be enough money for it to go to whoever your residuary beneficiaries are. So as an example, if you have, $10,000 to this charity and $20,000 to this charity and $10,000 to this charity, and then everything else you want divided among your kids may not get much of anything, because if your entire estate gets paid out to the charities first, there might not be much left. So obviously that's not going to apply if you have a lot of money and you're only giving small bequests. But so just keep that in mind, right? What percentage of those bequests are the total value of your estate? And how likely is it that you're going to spend so much down that you don't have a lot left anyway to satisfy those bequests? So just keep all that in mind. Again, if you want to divide stuff up among a lot of people, it's generally better to do it in a percentage, right? So I had someone the other day that did tons of percentages because that's what they wanted. And that's perfectly fine, because then it's just a percentage of what you have left. If you have $10,000 left, well, that's how it's going to be divided up. If you have $1 million, then that's how it's going to be divided up, based on percentages and not dollar amounts. In addition to, perhaps you want to do dollar amounts, perhaps you want to do certain assets, perhaps you want to do percentages. People always ask also about personal property. So how can I distribute my personal property to whoever you want to distribute it to? And so Arizona allows you to do what's called a tangible personal property statement or list. And what that allows you to do is put down, and it's only for tangible personal property. So it's not cash, it's not real estate, it's not bank accounts, it's not investment accounts, it's not money of any kind. It's simply tangible personal property. And tangible personal property is anything that you can touch in your house, right? So art, furniture, jewelry, tools, anything like that, anything that you can touch in your house. Generally speaking, those are sentimental items. They don't generally have a high dollar amount as far as the value, but they're sentimental, and people want those items themselves and not to sell them and just get the money. So what you can do is you can make a list of those items, and you can put, my diamond ring and who it goes to, my emerald earrings and who they go to, my piece of art. As long as you describe it sufficiently that somebody knows what you're talking about, you can use that. And that is simply, it can be handwritten, it can be typed, it can take any form you want, and then it just has to be signed. And it, in my opinion, should be dated. It's not required to be dated, but it should be dated in case you change your mind and update it. The latest one would prevail. What that allows you to do is you can scratch things off the list, you can tear it up and do a new list, you can add things to the list. It allows you to make that list for those items without having to change your will every time. So, if you want to leave a bunch of stuff to someone and then you change your mind later, you can just tear it up and do a new list, or you don't have to do a list. And you don't have to do a list at all. The list is totally optional, but it's a way for you to distribute those items without having to change your will every time. It's very useful. It's a very good idea to do that. The tricky parts to that are, make sure that you keep it with your will so that whoever's going to be administering your estate can find it, and making sure that it's clear enough what the item is. People fight a lot about personal property like that. So it's a really helpful way to make known what your wishes are about that. So that would be sort of these bequests that we're talking about. Let's say you say, I leave everything to my kids, but you don't want it to go to them until they reach a certain age. You can certainly put that in the will, that it should be held until they're 25 or 18 or whatever that age is you want it to be held. And you can have whatever provisions you want for that it's used for their college, or or they get a monthly allowance, or whatever it is you want. And yes, you can put that in the will. The other thing that is important to have in a will is, you want to leave, whoever you're leaving it to, you should also have an alternate, because what if that person dies before you? You need to have an alternate so that there's not another problem because you didn't name an alternate. And the same thing. So if you say, I'm going to give my car to so-and-so, well, what happens if that person dies before you? You want to have an alternate for that. I leave everything to my 2 kids. What if one of them dies before you? Do you want it to go to their kids, their share, or do you want their share to go to your other child? And so those are decisions that you'd need to make and put in there. The other thing that is required to be, well, I guess not required, but that's you need to have in the will is who's going to be your personal representative. That's who the person is that's in charge of everything. In Arizona, we call it a personal representative. In other states, it's called an executor, but it's just the person that's in charge, right? So they're going to be whatever's subject to the terms of the will. They're going to sell your assets, liquidate your accounts, whatever, and carry out the terms that you've put in there. So if you're dividing it, however you're dividing it, it's going to be their job to make sure it gets divided in that way. So the will really needs to have somebody named in there. And that's, again, where people make mistakes when they're writing it themselves. They forget to name somebody to handle that. And so then that becomes an issue. And again, you want to name an alternate for that as well, because what if that person, maybe they, die before you, but maybe they just can't do it. Maybe they are, they have something in their lives that means that they can't do it. So you definitely want to have an alternate that can do it. You also want to think about whether you want that person to have to get a bond. So when somebody is taking care of someone else's money like that, they're generally required to be bonded, which means they have to obtain a bond. It's like an insurance policy for the total value of the assets. So let's say your estate is worth $100,000. Generally, the personal representative or the executor would have to obtain an insurance policy for $100,000, which would mean that if that person ran off with the money or mismanaged it somehow, the bond would pay the estate back, and then the bond company would go after the personal representative to get their money back. So it's a protection for your beneficiaries. If you don't want that, so that becomes an expense that has to be paid out of your estate. If you don't want that, then you can put in the will that bond is not required. If you don't put it in the will, then a bond is going to be required. Now, my belief is if you're naming somebody that you're concerned might run off with the money, you probably shouldn't be naming that person. So I generally have bond waived in the will, because again, I feel like if you're really concerned about that, then please don't pick that person, pick somebody else. But again, that's up to you, but that's a consideration you need to make. And if you want them to be bonded, that's perfectly fine. You can certainly do that. But if you don't, then you need to make sure to put in there bond is waived, because if that language isn't in there, they're going to have to be bonded. Another thing is if you have minor children, you really need to name a guardian in your will who's going to take care of those kids if something happens to you. That's where you do that in a will. And then, they'll have to go through a court process in order to be appointed. It's not just, oh, okay, they're the guardians now. There's a process for that. But it gives that person, whoever you've named, priority to be the guardian of those minor children. So that's obviously very important. If you have minor children, you want to make sure that whoever you want to take care of them is able to do that. There's still a court process, because, you could have written this will a long time ago, and the court wants to be sure that that these minor children are going to be properly taken care of. Lots of things can happen between the time you write a will and the time it might need to be executed. And so they want to be sure that this person is still an appropriate person to be the guardian of these small children. Those are the basics of what you should have in the will. It obviously needs to be dated, signed. We talked about the witness requirements. It's a good idea to have it notarized. It should also say that you're revoking prior wills. If you don't, let's say you did a will 15 years ago, and then a new one that you're preparing needs to say it revokes all prior wills. Otherwise, now you're going to have you could have these conflicting provisions, and that creates a mess as well. So that should really be in there, that it revokes all prior wills. A lot of people say, well, what if I want to make an amendment to a will? You can do that. It's called a codicil. I generally don't suggest doing codicils that often unless there's a unique situation. Generally, we just write a new will for somebody. A codicil requires it's an amendment, right, to the previous will. But what it does is it requires you to have that previous will and the codicil, the originals of both. So it's more likely that you're going to lose 2 documents versus 1 document. So I generally just write people a new will. I think that that's just the better way to handle it. But there is a way, if you just want to make an amendment, you can certainly do what's called a codicil. So those are the basics of how to write a will. I do want to sort of go over what happens when you die briefly, and what implications there are with regards to those kinds of things. So what a will covers is anything that's just in your name when you die. So if you have a joint account with someone, the will doesn't cover that. If you have a beneficiary on an account, like we talked about, the will doesn't cover that. If you have a beneficiary deed for your property, the will doesn't cover that. If you have a trust and your assets are titled in the name of the trust, the will doesn't cover that. So the only thing that's subject to the will is anything that's just in your name alone, with no beneficiary and no joint owner on it. So that, again, just be aware that that's how that works. You have beneficiaries on things. You just want to make sure that you're understanding how your stuff works. If you have beneficiaries on an account, it's going to be paid to them. If you don't have beneficiaries, it's going to be paid to your estate, and then the will is going to cover that. So just be aware that, if you have different beneficiaries, the distribution of things could be different than what you were expecting if you have things set up differently. The other misconception that people have is, because I have a will, I'm avoiding probate. That is not the case. Probate is actually defined as the court process to administer the terms of someone's will. So just because you have a will, it does not avoid probate. So a lot of people think that that's the case, and it's not. So what happens is, like I said, if you were to die, your family or the person that you've named to be in charge of this is going to gather up and figure out what your assets are. Whatever is subject to your will. So again, whatever is just in your name is what's subject to your will, and that's what's subject to probate. And if that total is more than 75,000, then there has to be a probate. So the person that you've named to be in charge of everything is going to have to find your original will, submit it to the court with a bunch of other paperwork. The court's going to look it over with the will and say, okay, this is the person that's appropriate to serve, and they're named in the will to serve. Do they have to get bonded? What does the will say about a bond? And then they'll appoint that person. And then it's that person's job. Now they're the appointed personal representative. Now they're going to sell your house or liquidate your bank accounts or whatever the assets are that are part of the estate, and then distribute them according to the terms of the will. So that's a short version, but that's essentially the gist of what a probate is. If you don't have a will and you die and you have assets in your name, somebody is going to have to also go to court and open a probate. So a slightly different process because you don't have a will. But basically that's where it comes into play about who your heirs are. The heirs are determined under the statutes, the Arizona statutes. It defines who the heirs are, who can go ahead and apply to become the personal representative. There can be some arguments there, and then there's litigation, and that's a whole separate thing, but that's what happens if you die without a will. Obviously, a will can be contested. So let's say that you prepare this will and somebody doesn't, and you die and somebody doesn't like what it says. They think that they should get something, or they don't like that they only got a certain percentage. They think they should get more, whatever the story is. It can certainly be contested. And so there's lots of different ways to contest it. One of those are obviously that the execution requirements weren't met, which is what I talked about before. So if it wasn't witnessed properly, then obviously on its face, it needs to be executed properly, which is what I said before. I had a case several years ago where the person typed the will. It was very complicated. He thought he didn't have any kids and he wasn't married, and he wanted to leave his assets to two of his brothers and exclude one of the brothers. And he wrote all these terms. It was very complicated. And he only got it witnessed by one person. And that's not a valid will, unfortunately. So he didn't have a valid will. And so everything had to be divided equally among his three brothers, which is not what he wanted at all. And everybody knew that, but there's nothing that could be done because it wasn't a valid will. He didn't execute it properly. So that's an easy case where there was no litigation because there was nothing to argue about. There's nothing that could be done. But so that has to be executed properly. That's the first step. Now, assuming that it's executed properly, somebody can still contest the will and say it wasn't valid because the person didn't have capacity. So a capacity issue is that the person making the will has to know what their assets are and who their natural heirs are. That's basically the test for whether someone has capacity. And this is where I'm going back to a lawyer. It's a good idea to have a lawyer prepare it, because if you have somebody contesting the will later and they say, well, they didn't have capacity. If you have a lawyer that says, well, I met with them and I can tell you that they did, they were able to tell me who their heirs are, and they were able to tell me what their assets are. And they were able to tell me that this is who they wanted to leave everything to. That goes a long way to making sure that that person's intent is followed. If you don't have a lawyer doing that, and it's just somebody, you just signed it on your own, it's much more difficult to say, well, she or he knew what they were doing, when there's nobody to corroborate that. And you're not alive anymore to say that. So that's a really good reason to have a professional prepare it. The other way to contest a will is by saying that there was undue influence in the execution. So that would be where somebody has influenced the person to writing the will in their favor, right? So, there's three kids and one of the kids says, convinces the parents to leave everything to them. There's a lot of factors that go into undue influence. And that's way more than we can cover today, that's all very, it's a very subjective situation, but you just need to be aware of that's a way that somebody could contest the will. So if you're planning to, my advice is, if you're planning to disinherit someone, meaning if you have multiple children and you're going to leave one of them out, you probably need to have a professional help you, because that's where people get into trouble. They're going to leave somebody out, and that person is not happy about it later. And then that's where litigation ensues for the other children. So it's a really good idea to probably seek a professional in that situation. If there is debt in the estate, the debt has to be paid first before anything else. So the mortgage is going to have to be paid. If somebody is going to be receiving that house, they are going to have to get a loan in their name. The mortgage company is going to make them refinance that loan. The mortgage company is not going to be happy with just having a loan in the name of a deceased person. That doesn't work for them, because obviously if something goes wrong, they can't sue a deceased person. So once that title transfers over to whoever you're leaving the house to, they're going to have to refinance the loan in their name. And maybe that most times the house is sold, and then obviously the loan is paid off at that time when the house is sold, and whatever equity there is gets distributed to whoever you're leaving it to. That's the general way that it happens. But sometimes people want to keep the house, and they can, as long as they can refinance that loan. Otherwise, there's really nothing that can be done. If it's a situation where maybe there's only one beneficiary, it's one child and everything goes to that one child, and there's other money, that child can choose to do whatever they want with it, right? They can pay off the loan and then keep the house for themselves, or however they want to handle it. It becomes much more complicated when there's more than one beneficiary, because they're going to have to agree on what happens. Keep in mind that if you're not married, if you're with a partner and you're not married, it's very important that you make sure you have proper planning in place, because a not married person in Arizona doesn't have many rights at all. And so it's very important that you write a will to protect that person, whether it's, you can have joint ownership, you can have beneficiaries, you can do those kinds of things. As also, I think it's a good idea to also have a will so that that person is protected, because otherwise they're not going to be. And that happens quite frequently. People contact me and say, my partner, we weren't married, died, and there was no will. Unfortunately, there's not going to be anything that they can do. And I'm sure that that wasn't the person's intent, but that's what happens. All valid debts are going to have to be paid out of the estate. So that includes credit card debt, taxes, whatever debt might be out there, medical expenses, final expenses like that. Those are all required to be paid before distributions to your beneficiaries. So, debt on the house is easy because the house just gets sold and it gets paid off automatically, but credit card debt's going to have to be paid. Now, a lot of times the personal representative can try to negotiate a credit card debt down, especially if there's been interest and late fees that have been paid after death, that you can usually negotiate those off. But yes, all the debt, whatever debt you had, is going to have to be paid before anything gets distributed to the beneficiaries. The way that it works in Arizona is you own the home. There's just a lien against it for the mortgage. So a lot of people think, well, I don't even own the house, the bank does. That's not correct. In Arizona, you own the home. There's just a lien put on it for the loan or the mortgage. So the person can transfer the home into their name, but the mortgage or the bank is going to require them to refinance the loan into their name so that they have the liability on that loan if they stop paying or something. So the other thing I wanted to cover was, in addition to wills, which are very important, obviously, the other important estate planning documents that you should be aware of are powers of attorney. So a will only applies at death. The will covers what happens to your property and who's in charge and who takes your minor children at your death. But what happens if you're incapacitated during your lifetime? You get dementia, or something else horrible happens to you and you can't make decisions for yourself anymore. That's where powers of attorney are important documents to have. So there's financial powers of attorney and healthcare powers of attorney. A financial power of attorney is somebody to make financial decisions for you if you can't, right? For whatever reason, if you have dementia, if you're in a coma, something like that, you name someone now while you have capacity to make those decisions when you can't. And it's all financial decisions, right? Is your house sold? Are your bank accounts closed? Who pays your bills for you? All those kinds of things. It's very important to have, because if you don't have that and you become incapacitated, somebody's going to have to go to court to become your conservator to do those things for you if something happens to you. And so a power of attorney is very important to avoid the need for the court involvement. The court involvement can be very expensive. And so it's generally better if you have a power of attorney. There's also what's called a healthcare power of attorney. So that's who's going to make healthcare decisions in the event that you can't. Who's going to, and this is end of life decisions, but it's also decisions anytime you can't make them. So you might just be in surgery. You might just have fallen down on the street and you're unconscious, and some decision about your medical care needs to be made. Who's going to do that for you? And again, if you don't have that and something happens to you, then someone's going to have to go to court and become your guardian. And again, that's not the best necessarily. It's not the best process to have to go through. It can be very traumatic for people. And it can also, be very expensive. And so ideally, you'd want to avoid that using powers of attorney. So a guardianship and conservatorship is something that has to be done by a court. A judge has to do that. It's a process. Paperwork gets filed. There's an attorney appointed to represent the person. There's an investigator appointed. There's a lot of things that go into a guardianship and conservatorship. It's a court process. And once you go through that process and the court appoints someone as the guardian and conservator, they are the guardian conservator, and they have priority over anything else. They are making the decisions. So whether you have a power of attorney or not, doesn't matter. The guardian and conservator override that power of attorney. A guardian and conservator has the power to make decisions that you don't agree with. A power of attorney is a document that gets signed by you, and it's a consensual relationship. So it doesn't give the person that you're naming the power to override your decisions, in the sense that if you disagree with the decision that the person you've named has made, you can just revoke that power of attorney. You just revoke it and you say, that's it, you're done. I don't want you involved in my decision making anymore. You cannot do that with a guardianship conservatorship because a court has appointed that person to do it. So that's basically, I mean, obviously these things are a lot more involved in that, but those are the basics about how those work. The power of attorney dies when you die. And that's when the will takes over. So, you know, sometimes if you're acting in a power of attorney and someone dies, you know, a bank or somebody will say, oh, I need a power of attorney. That's not correct. Legally, they're not allowed to accept a power of attorney when the person has died. I wanted to mention those things because it's important when you're doing, you know, a will is obviously very important for what happens to your property and everything at your death. But it only affects what happens at your death. Powers of attorney are important to have while you're alive in case you become incapacitated. And that's all sort of a package that you would want to do if you're doing estate planning, is you'd also want to do powers of attorney, because it all kind of goes together in making sure that you have your affairs in order. Be very careful about taking advice from people that work at banks. A lot of time, you know, they're very well-meaning and they want to help you, but it's not generally, you know, they're not lawyers and they don't necessarily know what the best thing for you is. A lot of times people will say, oh, no, just add somebody as a joint owner on your account. That'll cover everything. You don't have to worry about anything then. That is terrible advice. Do not do that. Having a joint owner other than your spouse, if it's your spouse, it's perfectly fine. But having a joint owner on your bank account who's not your spouse is a very bad idea. That means that they are joint owner on that account. And so they can go in and take money out of your account at any time. There's nothing you can do about that. It also becomes an asset of theirs. So if they get sued, if they're going through a divorce, if they're going through a bankruptcy, the other party can take your account because you've now put this joint owner on there, meaning it's their account. So it's a really bad idea to have somebody who's not your spouse as a joint owner on your bank account. And the banks like to give that advice to people, and it's really, really bad advice. The way to do that is to have, you know, let's say it's your son or your daughter, you want them on your account to help you if something happens. The way to do that is a power of attorney. And if you want them to get the account at your death, it's a beneficiary. That's the way to do it. That's the way that protects you. And that's the best way to do it. It doesn't make them an owner of the account. It simply gives them the power to help you if you need help and to get it at your death with a minimal amount of hassle. And I mentioned before, there's also what's called a beneficiary deed for your house. That's a way to, like we were talking before about having beneficiaries on your accounts. That's the way to have a beneficiary on your house. You record the beneficiary deed now, and then at your death, it automatically passes to whoever you've named on your, on the deed. So the caution I would give you there is don't put too many people on the beneficiary deed because they're going to own that house together. So if you have 3 kids and you're putting them all on this beneficiary deed, they're going to own that house together. And so they are now going to be, you know, they're going to have to agree on when the house is sold, how much it's sold for, who's going to pay the taxes, the insurance, the utilities in the meantime while it's waiting to be sold. I mean, it can cause a lot of problems. I've seen that many, many, many times. So just be mindful of that. Again, I would advise you against having a non-spouse on the title or on the deed to your property, because again, you're in the same scenario. If that person gets sued, goes through a divorce, goes through a bankruptcy, they're now, the other party has the rights to take your house because they're an owner on the house. So I generally would not do that if it were me. Hopefully this was helpful information. Thank you.